Judge Cannon considering major motions for Donald Trump in the classified documents case. One of those motions has already been denied. Trump wanted to dismiss this case based on the idea that Jack Smith's charges were unconstitutionally vague. We'll talk about that one. But there's another one that's very interesting that she still has to decide on, and it is regarding the Presidential Records Act. Whether or not Donald Trump can declare records personal, meaning they're outside of the scope of the federal government, and how to enforce that, and does this justify a dismissal of the entire indictment? And we're waiting for a ruling on this one, but even if Cannon comes back and dismisses this one, during the hearing today, when they were arguing and debating these motions, there was what seems to be a consensus that Judge Cannon was very upset about the selective enforcement, the selective prosecution, the malicious prosecution of the Biden DOJ. In other words, the discretionary enforcement of the Presidential Records Act has been applied differently to Trump. It's been prosecuted against him, but not prosecuted against other people. How come that is? And so Cannon is saying that there may be some problems here that she'll address at a later time, but we're going to go through both of these filings and see what happened in court today, because we're trying to get our bearings straight on what Judge Cannon is doing. And of course, Donald Trump was also out. He's commenting on the distinctions between his classified documents case and Joe Biden's classified documents case, one of which is being prosecuted, the other is not. So let's take a quick look at the motion that was denied. So recall here, previously on our channel, we read through Trump's motion to dismiss, saying that all these 32 counts were unconstitutionally vague. And Trump submitted his reply brief and he made the same argument. So Jack Smith said, no, they're not unconstitutionally vague. He said, yeah, they are. And he said that these counts should be dismissed. So we need actual notice, and all of this stuff is too vague to provide us with the notice that we need. Therefore, the case should be dismissed. Now, there were oral arguments on this. Judge Cannon came out and denied it pretty quickly. And this was one of many different motions. And so we're expecting most of these to be dismissed, but you only need one. So here is what she wrote. She said, here's my order denying without prejudice, meaning Trump can come back here and file this again, saying this cause comes before the court. This is Trump's motion to dismiss, saying Jack Smith responded in opposition, and the court heard oral arguments on March 14th. That's today. Order came out immediately, saying, well, upon careful review of everything, Judge Cannon came out and said the motion is denied. Okay, so Trump loses, but it's without prejudice. Maybe Trump comes back. They say Trump seeks dismissal of counts 1 through 32 of the superseding indictment, that's Jack's indictment, on the ground that the statutory phrase is, quote, unauthorized possession. Okay, what does this mean? Put it in quotes. Unauthorized possession. How do you define that? Complicated. Same thing. Relating to the national defense. How do you define that? Entitled to receive. Trump says these are all unconstitutionally vague as applied to the president. Okay, these statutes are for non-presidents. They're for the general public. So when the president has special presidential powers, how do you apply them to the president? And in that situation, they are vague. Trump said that violates my due process, and the rule of lenity means that you should interpret it in a way that doesn't lead to the prosecution. Now, although the motion, says Cannon, raises various arguments warranting serious consideration, the court ultimately determines, following lengthy oral argument, that resolution of the overall question presented depends too greatly on contested instructional questions about still fluctuating definitions of statutory terms or phrases as charged. Sounds like it's kind of vague to me. In other words, like, yeah, it's hard to analyze this because there's a lot that we still don't know yet, along with at least some disputed factual issues as raised in the motion. So it almost sounds like still fluctuating definitions seems like it's kind of vague. Like, we don't know. So it's either this or it's either that. So there are some vagaries, but it's not necessarily vague as of yet because we just haven't decided what the definition is. Now, once we decide what the definition is, then I can maybe decide if it's vague, but we're not clear on the definitions. So because we're not clear on the definitions, I can't say whether it's vague or not. Maybe once we settle on a definition, then I can tell you whether it's vague. And I know that sounds convoluted. It sounds even convoluted coming out of my mouth. But for that reason, rather than prematurely decide now whether the application of the law in these circumstances yields unsalvageable vagueness, because we don't have the definitions to measure whether they're vague or not, I can't decide whether they're vague. Despite the asserted judicial glosses, this court elects to deny the motion without prejudice to be raised as appropriate in connection with jury instruction briefing or other appropriate motions. Okay, so it's not even a real denial. It's kind of like just bring it up later. So accordingly, it is hereby ordered and adjudged that Trump's motion to dismiss these counts is now denied without prejudice, done and ordered in Judge Cannon's court. So pretty quick one. We'll get through that one pretty quickly. Bring it up later. If you think it's unconstitutionally vague, let's let this case mature a bit so we can decide on what these definitions are. And then at that moment, we can say, well, yeah, that definition, government, is vague. And so now we can't come up with reasonable jury instructions when we're briefing these issues. And therefore, maybe we renew a motion to dismiss because you don't even know, state, what your argument is. All right, so judge denies that. Now, we were still in court on the day. This is what it looked like as people were outside supporting Trump. He rolls in, and we're going to see what oral arguments look like on the other motion. This clip came over from our friend at Benny Johnson on the X platform, and here is what the reporting sounded like outside Florida.
Same time watching the former president arrive, and now we are again a couple weeks later. And what we remember from that day, Dana, is the number of supporters who were on that road as he arrived, and we expect a good number of people to be there too. They stayed the entire time that he was inside the courtroom.
Right. The other thing is that we're going to see a lot of this through this campaign season. The House Republicans invited President Trump to come to his retreat, their retreat that's in West Virginia today. Of course, you could imagine he would want to be there, but he said, I have to be in court. So that's why he's there
his
today.
political
this in light of the Robert
him.
Hur testimony from 2 days ago, where the Republicans proved that there were 7 different locations where Joe Biden kept classified material when he was out of the White House. In various places, the Biden Center, the Penn Center, a couple different places in his house in Delaware, and on it goes. This is what Trump's team is going to argue, a similar matter when it comes to classified documents under the Presidential Records Act being held in Mar-a-Lago, Florida.
That's exactly right.
That's the argument they're going to put before the judge and trying to get some of these cases and charges dismissed.
And there's no cameras in the courtroom. We will provide you information throughout the day. It is expected to be a long hearing.
It went most of the day, and we're going to get into what happened. But as you heard there, they were talking a little bit about the discretion, right? Why was one set of facts, why was one president or vice president prosecuted or not prosecuted, but the other one was? And it's because of prosecutorial misconduct, which I think may be the exact issue that disposes of this case. We'll see. But the other one that has a lot of overlap with prosecutorial misconduct, with malicious prosecution, is what are they misapplying? What law are they perverting to apply leniency when they apply it to one person, but then to apply aggression when it goes to someone else? Well, the law is the Presidential Records Act. When Bill Clinton said those are personal records, no one batted an eye, right? Judicial Watch sued Judge Amy Totenberg, said, yeah, he's the president. What am I supposed to do? Say that they're not personal records? He's the president. Take it up with the Constitution. We have separation of powers in this country and in our Constitution. And if you don't like it, Judicial Watch, get out of here. And guess what? They had to go. So how come now it's being reapplied differently to Donald Trump? Well, this was Donald Trump's final reply. So he sent this one back in before the oral arguments took place today in court in Florida. And here was what Trump's argument said before we see what happened in court. Arguments came in. Donald Trump says, all right, Judge, listen. President Trump here respectfully submits this reply saying that we need to dismiss the entire indictment because the Presidential Records Act tells us that we have the right to do this. The indictment must be dismissed first because Trump designated the documents in counts 1 through 32 as personal records. And Jack's office is foreclosed as a matter of law as saying that the retention of those records was unauthorized. DOJ, NARA, and even the Biden White House counsel have also taken similar positions. They have all historically argued that the PRA designations by former presidents and vice presidents are not reviewable in criminal proceedings. Asterisk, unless your name is Trump, but Trump. So the office's contrary position in these proceedings, now they just changed everything. DOJ, White House, and NARA, previously to Trump, they all said, you can't charge somebody for this. Now they have. Now, Jack's office position, contrary to this, is meritless, and it's precluded by estoppel principles, meaning if you haven't pursued it in other cases, you can't just suddenly pursue it here. And second, because NARA, the National Archives, the head librarians of our whole country, who apparently are more powerful than the president, we learned, and because NARA's actions were politically motivated, thanks Deborah, and driven by the Biden administration as a political weapon against President Trump, NARA's February 2022 sham referral and its May 2022 rejection of President Trump's executive privilege claim violated the APA, the Administrative Procedure Act. And as to the referral, in light of the unbroken chain of custom and history of NARA inaction with respect to these record designations, in other words, NARA has never quibbled over how presidents declare their filings, their documents. These are personal, these are presidential. If they're presidential, they are presidential records. They go and they be archived, they go into the library. Got it. But if they're personal, like Bill Clinton's sock drawer tapes were, he gets to decide that and he gets to keep them. No one's ever quibbled over that until Trump. Then NARA gets involved. They make DOJ referrals and they pass this thing off to illegal, unconstitutional special counsel who's illegally appointed. So there were not reasonable grounds to believe that there had been a violation of federal law. There was no precedent for this. No one could expect or have noticed that they would be charged for this. Now, therefore, the Non-Espionage Act, writes Trump's team, charges must be dismissed as well. So you can't hit him with this. They say, here's the deal. Judge Cannon, President Trump's designation of records as, quote, personal under the PRA by allegedly removing them from the White House while acting as president is not the product of alchemy. Okay, we're not smashing this together. Rather, Rather, this is the only fair inference from Jack Smith's allegation in the superseding indictment. They say President Trump caused boxes to be transported. So the president caused the thing to happen. And obviously that happened while he was still president. Jack Smith has even acknowledged that. So while he made this decision, he was president. He was exercising his presidential powers. And because you can't quibble with that decision, and there's no precedent of anybody quibbling with that decision, you're done. You can't suddenly say, that's illegal. They say this is also the same inference that DOJ, NARA, and a district court granted President Clinton in judicial watch. Similarly, in January 2023, a NARA official wrote to former presidents and vice presidents to inquire about materials previously assumed to be personal in nature. The office makes no effort to address the judicial estoppel implications of the DOJ's representations to the court in judicial watch or Crew versus Trump. So in other words, why should the DOJ be allowed to have two standards? If they pursued and defended the president in judicial watch or Crew versus Trump, they can't turn around now and say the opposite standard applies. Now they say, look, people will turn around and they'll say, President Trump returned those boxes because he knew that they were illegal and he didn't have lawful possession. And they say, no, that's not true. Get out of here. They say President Trump's subsequent decision to give those boxes back does not invalidate his earlier designation. They're still personal records. He just gave you those back. Now, by giving each president complete control over his personal papers, Congress hoped that it would encourage presidents to create and preserve such papers, and that presidents would later voluntarily donate those papers to the National Archives. Saying the superseding indictment, as they continue, Trump's team, it fails to state an offense. Nothing criminal happened here because the PRA, the Presidential Records Act, it authorized Trump to make and take possession of his records under his presidential authority. Now, the argument to the contrary by Jack proceeds by characterizing the law as a delegation of authority to the executive branch, saying the National Security Act was signed in 1947 prior to the enactment of the PRA, and then President Truman signed another executive order, and so thus by the time Congress enacted the PRA in 1978, it was well aware of the authorities it was relying on, and Congress did not draw the distinction pressed by the office between the classified and unclassified records, saying the text of the National Security Act does not support the position of Jack's. The office admits that Congress exempted the president, from the scope of the regulations. Right, because the president is the root power. Plus we have a constitutional amendment. If Congress can just pass a statute that can dictate what the president can or cannot do, Congress is the presidency. So all these whack jobs on cable news who say that, certain rules apply to the president that apply to every other officer in the world, not true, right? Because he is the enforcer. If somebody can pass a law like Congress by statute, not by an amendment that would actually modify the Constitution, then they can just usurp the presidency by statute. So Congress even admits that when they pass this stuff. They exempted literally the president from the scope of the regulations. But the office contends that the exemption is irrelevant because it doesn't apply to a former president. So what? The causing of the movement of the boxes and the delegation to the Presidential Record Act as personal happened at the time he was president. The assertion misapprehends that relevant time frame. Trump designated the records as personal under the PRA while he was still in office, not as a former president. At the time of the designation, he was expressly exempted from the provisions of the rules. For that reason, the 11th Circuit assertion in a different setting that executive order pertains equally to former presidents is of no consequence here. And furthermore, this other executive order does not override the PRA. Thus, the executive order addresses this, but the executive order makes no provision for records the president designates as personal. So he's allowed to maintain jurisdiction and custody over those. The suggestion by Jack's office that Trump's designations of the records is implausible does not stand to reason. Surely no one from the National Security Council or the intelligence community left individual documents in the Oval Office following briefing to Trump. The PRA gave discretion to the president to designate those records as personal, and NARA's responsibility under the PRA is expressly limited to those deemed presidential. So Deborah didn't have any jurisdiction over those personal records, and NARA did not assume responsibility for those records designated presidential until after Trump's first term. So none of these provisions distinguish between classified or unclassified records. So Jack Smith cannot escape the importance and these textual commitments. The rules give Trump authority. Trump also made his designations with the full force of his Article 2 authority. As the president that we talk about here, the opinion clause, the president has the right to the opinions of the leaders of his executive branch in writing. The Constitution says it. I think it's Article 2, Section 2, Clause 1, if I'm right. And it's right in there, right? And it's a powerful provision. So he gets that. Now, as a result, President Trump's designation of the records as personal, they failed to state an offense under this indictment. Therefore, these charges must be dismissed, saying there is no constitutional question for the court to avoid, is in the opposition. They say the DOJ and NARA, the National Archives, they invoked the possibility of, quote, stark separation of powers problems in the Judicial Watch case versus Bill Clinton. In Judicial Watch, the concern was that judicial review of President Clinton's individual document designations would lead to an impermissible interbranch conflict. The argument was well-founded. Absolutely. It was actually a good argument. And it was by Judge Amy Totenberg. We read it here on our channel. She said, the archivist also lacks the authority under the Presidential Records Act, the head librarian, to inspect the president's records or to survey the president's records management practices, because the archivist is not above the president. MSNBC? God. The court is left with the undeniable conclusion that Congress vested almost no authority in the archivist and NARA over vice presidential records during a vice president's term, right? Those are quotes from other cases. Crew versus Cheney. She's just a librarian, right? She doesn't get to make criminal referrals to the DOJ, but that's what they did with Trump. But they didn't do it with Clinton. In fact, when they tried to get Clinton's tapes, the judge said, I can't overrule the president. I'm a separate branch of government. It's his docs. It's his power. Leave him alone. Judicial Watch did. Now they want to reverse that. So as was the DOJ's contention to another federal judge in 2023, which Jack Smith's office does not even address, another case, the DOJ said this, DC Circuit precedent provides that the court lacks jurisdiction to review day-to-day White House records management decisions under the Presidential Records Act. They say, wow, that's really convenient. So you submitted that in another case. Courts lack jurisdiction to review White House records. Weird. But then you prosecute Trump for those. Huh, they write. Indeed, yeah. Congress was keenly aware of the separation of powers concerns that were implicated by legislation that regulates the conduct of the president, because Congress can't do that until Trump. And they sought assiduously to minimize outside interference with the day-to-day operations of the president. Now, courts have no jurisdiction to review the president's day-to-day operation. That's Marbury versus Madison. If the courts can review the president, guess what? They're the president. And they're not. Neither is Congress, no matter how bad Liz Cheney wants it to be that way. The unreviewable day-to-day operations of the White House include, says Trump's defense, PRA designations by President Trump during his term in office. Obama did not suggest otherwise when he issued executive order decades after Congress enacted the PRA, because the definition of records in that order expressly does not reach personal records. And the court would not disrespect the executive order or the executive branch by interpreting the PRA according to its plain terms. Thus, the constitutional avoidance canon has no relevance here. They say Jack Smith also, they're trying to escape history. Deranged thugs won't even read the history book. We've got bad history for them. It's called the Judicial Watch case, which we've talked about. They say, hey, Judge Cannon, Jack Smith can't run from this. President Biden's, President Clinton's classified tapes, President Reagan's classified diaries, and recent positions taken by Biden's White House counsel all support Trump's motions. Jack does not dispute that President Clinton's tapes contained classified information. They say that's true. That much is clear. In Judicial Watch, in that case, a DOJ attorney represented to a federal judge that President Clinton, quote, presumably classified the tapes as personal records by not transferring them, right? Clinton, if he thought that they were presidential records, he would have transferred them into the head librarian at the time. He didn't. So by default, the presidential decision means they're personal records. That is what a prior judge decided. And it makes sense, because if the judge, or even if Clinton has to fill out a form, right? Before you can take those records, Mr. President, please complete this form. What happens if I don't? Oh, well, you're going to be in violation of the law. For what? Access to my own documents? They're not yours. And you are not the president. And so your little form here is bureaucratic nonsense. It's not in the Constitution, and I don't have to follow it. So by not giving it back, that's the decision. Now, that contention alone should be extremely persuasive in this proceeding, obviously, involving attorneys representing the same government. The DOJ made the argument that Clinton could do that. They said by not moving it, they're his. By not transferring it back, they're his. He took them with him, didn't give them to the government, they're personal. Trump did literally the exact same thing. But President Trump's reliance on Judicial Watch is not limited to that part of the transcript. DOJ also contended in the Judicial Watch, when they were representing Clinton, that the PRA's administrative enforcement scheme is exclusive, right? So that if there's a problem with the documents, it's administratively dealt with, and argued that Congress would have to pass a new law, DOJ wrote this, to address any problems with presidents not properly designating records under the PRA. You can't charge a president under espionage. That's their prior rules. There is a bill pending in the House of Representatives that may accomplish some of these things, says Trump's defense, but the absence of such an enactment in January 2021 further supports Trump's position that the PRA applies without limitation to the records at issue in this case. And Jack Smith has failed to address the significance of 1791. So if Congress is now jamming a new bill through to close the hole, well, maybe they're exploiting an area of the law that was not clear. Trump did not have proper notice. It's a violation of his due process to prosecute him for something that he doesn't have awareness of is even a crime. Now, the court in Judicial Watch, Judge Amy Totenberg, agreed with the DOJ based on reasoning that is persuasive here. The PRA only authorizes NARA, Deborah in Trump's case, to take possession of records that were designated as presidential. Now, the designation decision is to be made by the executive. The president makes the decision, not Deborah. NARA lacks the mandatory or even discretionary authority to challenge those designations, and the PRA provides NARA with no role with respect to personal records. So Deb can't question Trump's decision, and when Trump makes a personal record, that pulls it from her jurisdiction in the first place. Judicial Watch is the only case cited by either side involving document-specific PRA designations, as opposed to presidential agreements with NARA in tension with the PRA and the president's PRA policies and guidelines, which are subject to review in civil and administrative proceedings. There are other ways to deal with this. The DOJ and NARA, they did not question President Clinton's possession of tapes, and those tapes contain classified information. And it was inconceivable to all involved in Judicial Watch that there was any mechanism, much less a criminal mechanism, to recover them directly from a former president. Nobody thought it was even remotely possible to go arrest Bill and rummage through his sock drawer. Need a biohazard suit to do that. DOJ, NARA, and other agencies took the same approach with respect to Reagan's diaries. Reagan had a bunch of classified stuff in those diaries. But Jack Smith's office tries to seize on the reference to diaries as the definition of personal records. That argument is inconsistent with the office's attempt to harmonize the law with the executive order. If executive order and its predecessors apply to classified information in personal records under the PRA, which would be inconsistent with the order's definition of records, then the order's predecessors apply to Reagan's diaries and Clinton's tapes to the same extent they apply to Trump's. You can't have it both ways. They apply or they don't. These are the real world facts, Jack. No one interpreted these authorities in that fashion until Trump announced he was running for re-election, then everything changed. Not even the Biden administration, says Trump. Specifically, the White House counsel's office and Mr. Biden's personal attorneys, they've also argued that the PRA authorizes a former president or vice president to keep classified materials in locations that are not approved for classified information at home, as long as those materials are not defined as presidential records under the PRA. That's from the Her report. All right, so pre-Trump DOJ, pre-Trump NARA, pre-Trump Judge Amy Totenberg, well, this is current Trump, but even current Joe Biden, all say president has exclusive control over the PRA, can declare what is personal or presidential, can make decisions just without even speaking, just by taking action, and that the remedy for any violations of this is through civil and administrative procedures. And how dare anybody even think about criminal charges for Reagan, for Clinton, and for the others. Now, this special counsel's office should not be able to suddenly do the different and prevail on the contrary position here, trying to incapacitate Biden's chief political rival and former president and Republican nominee for the president. It's official now. Congratulations to Trump. Now, they say NARA and their unlawful agency action, Deborah, sending this stuff over to the DOJ, it supports dismissal because this was inappropriate. The Non-Espionage Act counts in the superseding indictment, says Trump's defense, cannot stand here because they are based on unlawful agency action. NARA violated the law. Saying here's how that worked. Beginning in September 2021, NARA worked with the Biden administration on a politically motivated mission to investigate Trump by abusing the PRA. NARA's response to this political pressure renders the unlawful the agency's actions, including the sham referral in 2022 and the May 2022 purported waiver of Trump's executive privilege. They just waived it for him. Jack Smith's office cites this law, but it fails to respond to Trump's additional argument that the sham referral itself was unlawful. In light of NARA's customs and practices before all this, there were no reasonable grounds to believe that there had been a violation of the law. Trump's retention of personal records was not unauthorized under the law. Look at all the other presidents. Therefore, her referral was an improper agency action, violated the APA, and courts have dismissed charges that are based on unlawful agency action. And they say, finally, it's very easy, Judge Cannon, says Trump's defense, very straightforward to reconcile President Trump's position that a president's designations under the PRA of individual documents as personal cannot lead to the unauthorized possession of those documents. That's ridiculous. If he says they're personal, they're his. And that is supported by prior positions of the DOJ, NARA, and the White House counsel from Joe Biden themselves. They all know the exclusive nature of the civil recovery mechanism has been been incorporated into the law. They've conceded in the prosecutorial misconduct opposition. They concede that NARA has no enforcement authority. So NARA referred it to the DOJ and they did it. They say agreements, policies, and guidelines relating to the PRA may be reviewable, but that must occur in civil proceedings, not criminal prosecutions, which is why they gave it to the DOJ, and Merrick Garland kicked it off to Jack Smith, who's illegally appointed. They say, in addition, Judge Cannon, to our knowledge, there has never been an effort to use a civil replevin action to collect presidential records from a former president, a return of property. Rather, all replevin actions for this purpose have been brought against third parties and presidential successors who never wielded authority under Article 2 or discretion to designate these as personal records, right? Like other people who are not president. The absence of a criminal penalty in the PRA and the existence of an exclusive civil recovery mechanism that has not been applied to former presidents are both consistent with this motion. And such a lack of historical precedent is generally a telling indication of a severe constitutional problem with the asserted power here. Jack Smith's office expresses concerns that a former president might, quote, try to sell personal documents to the highest bidder. That is what President Clinton did by permitting Taylor Branch to write about tapes containing classified information. In response, the DOJ and NARA hardly lifted a finger. No one raided Bill Clinton's disgusting home. The special counsel's office should not be permitted to predicate an unlawful prosecution on a contrary interpretation of the PRA, and for the foregoing reasons, this superseding indictment must be dismissed. Respectfully submitted by Todd Blanche and Christopher Keese. Good motion, and I think, it's clear. There's a massive double standard that exists under the Presidential Records Act, but she may not bite on this one, right? She might want to save it for the selective and vindictive prosecution filing or order additional discovery, because this is the misapplication of this, right? This is the rule that was misapplied, but now we're talking about the people who did the misapplying, and that's in the vindictive and selective prosecution motion, which was unfortunately filed under seal, so we do not have that one to read. But let's take a look at what happened in the proceeding today, and we had a brief update here from the Epoch Times, who were there in the court building. They're inside the court building, and let's just see what some of this looked like as the day unfolded. So we arrived, we're on scene there in Florida. Bright and early in the morning, former President Trump's motorcade pulled up to the Florida courthouse. Cheers of supporters chanting Trump, Trump, Trump. As with most court appearances, it was a lively morning. Cannon enters the courtroom. All rise, please be seated. She says, good morning, everybody. We're here to talk about the motions to dismiss. We're going to start today with the unconstitutional vagueness motion. Trump's attorney, Todd Blanche, says, Your Honor, good morning. These charges must be struck and dismissed. The judge asked some series of questions about whether this was premature. Mr. Blanche, isn't this a little premature? Seems like you might be talking about some stuff that exists outside the indictment. And Mr. Blanche said, well, Your Honor, I think it's appropriate here. Other cases have done that as well. And Mr. Blanche brought up what we just talked about. He said, by the way, Judge, Bill Clinton and Ronald Reagan and even Joe Biden, his situation, all of those situations are parallel to this current case. All of those presidents retained documents after their presidency, said Mr. Blanche, and the Department of Justice was complicit in that. They allowed them to take those documents, and they chose not to prosecute them. So it's unspeakable, says Trump's defense, that the DOJ is here today approving and even prosecuting this case. We know that Clinton's tapes were very serious, Your Honor. Clinton shared tapes containing military information with his biographer. Cannon said, well, those contain classified information. Mr. Blanche said he didn't know, but we know because they referenced it in their motion. In their own motion, they said that did contain classified information. Cannon was still thinking through this. She says, I want to dive into this. What is the definition of unauthorized? Trump defense. What is unauthorized to you? Blanche said, I don't know, Judge. Judge, I don't have a response to that. I can't define that. I'm a defense attorney. Talk to them. Judge said, I'm a little frustrated about this because we're going to have to get it in jury instructions and everything. What I'm trying to get at, Mr. Blanche, says Judge Cannon, is who would be entitled to receive these classified documents? Who can get those? What is authorized? What is unauthorized? And Trump's defense said, well, Your Honor, there's an extremely problematic situation here. Obviously, there's a lack of a legal definition. We got these weird terms like need to know when it comes to classified information. No one knows what they mean. It varies case by case because you might need to know, but you might not need to know, and who knows? So the judge said, Cannon, this indictment, by the way, I was looking at it, it alleges that it became a crime the day after Trump left office for him to have the documents, whether or not he designated them personal. Is that right? Trump's defense said, well, I want to distinguish this. Here's another parallel. Joe Biden retained classified documents, and the DOJ chose not to prosecute him because they didn't determine there was a crime. And so the retention issue should not be a crime in President Trump's case either, right? Being in simple possession apparently is not a problem. So that's alone not enough, right? The possession of the documents. Judge saying, interesting. Now in the motions, the attorneys say that count 19 should be struck. Cannon says, is there an official process to transition or to remove president's clearance? Defense team said, no, there is no formal mechanism. If it happens at all, there's no real mechanism. So it's just kind of inconsistent, like they don't have an exit process for the presidency. Cannon says to the defense, would other officials run afoul of what the DOJ says is illegal in President Trump's case? Like if he got prosecuted for this, would other DOJ officials? He says, absolutely. Yeah, a bunch of people would if they held this standard, but they only hold a standard for him. Now the judge says, okay, thank you, Mr. Blanche. Let's hear from the government. Jay Bratt stands up, this guy. He's up for the prosecution. He says, Your Honor, President Trump could not have designated the classified documents as personal records. They're classified. You don't get to classify classified records as personal documents. He said, Your Honor, by the way, I want to tell you about this recording. You know, Trump made a recording after he left office. He referred to a stack of classified documents. He says, I could have declassified, but I hadn't. Bratt argued that this was his admission that the documents had not been designated as personal. And he said the Presidential Records Act anyways allows presidents to deem personal correspondence only, Your Honor, as personal. And official documents related to the government would by definition be presidential, right? So he wants a different definition of this. The president, according to our, broad interpretation, can just declare either way. I declare this is personal, presidential, doesn't matter, classified, whatever, it's mine, which I think is the ultimate interpretation of this. Like, again, if someone else can tell the president, oh, sorry, that's classified and you can't have that, I need to see where that authority comes from. Like, where is that authority? If someone can point me to something that overrides the president's, then okay, I'll believe that. But if it's a congressional statute, if it's U.S. code, or if it's some executive order from a former president or something like that, no, right? It's the president's discretion under the Constitution, Article 2. So it's much more broad. So he wants a much narrower definition to say that Trump is illegal. So Cannon says, well, I want to ask you about this timeline, Mr. Jay Bratt. How come the investigation, Jay, wasn't open the day after President Trump left office? Like, if this was so illegal and NARA is throwing themselves into such a hysterical fit over this, how come they didn't open the investigation the day after Trump left office? I mean, if that's the moment it became illegal, says Judge Cannon, then how come you didn't start investigating him then? Well, they said, well, President Trump, Mr. Bratt, he says, well, could have realized and returned the documents later, I guess. Well, the judge asked, was there an official person designated to receive those documents if he returned those documents? And Bratt said, even if President Trump had given the documents, to like his Republican friends in Congress, this case would have never been brought. I don't care where he got them, maybe a ballot drop box or something. It would not have been returned to the correct person, but he would have sought to return them. He argued he could have sought to return them, even if he didn't know where to give them back. So the judge is like, was there like a library drop box? Like, since you have a head librarian, Nara, does she have a drop box that's convenient for him to drive through? He said no, but he could have figured it out. And Bratt said, security clearance isn't even specifically given to a president. So there's not like any clearance at any point. He said presidents instead get lawful access to classified information during their time in office. But this only allows them to view the information at work, and not to take them home and put them in his basement or garage or drawer or any one of Joe Biden's other 5 locations. Certainly, the judge said, seeming to side with the prosecutors on the idea that Mar-a-Lago was a residence and not, as Trump said, an authorized space for classified documents. Bratt said the lawful access ends when the presidency ends. And Cannon said, well, okay, Mr. Bratt, I want to address some cases concerning other presidents with you. How about these past presidents and these vice presidents? I mean, Mr. Bratt, you brought up other officials being prosecuted who have retained classified information before, but now I want to know, how come history would not then inform a sitting president of what was acceptable, right, Mr. Bratt? I mean, listen, if past presidents had been able to retain classified information and not be prosecuted for that, what would lead the next president to believe otherwise? If they didn't get prosecuted before, why me? She asked if this would not make it a case of arbitrary enforcement. Now, Mr. Bratt could not name an example. Can you tell me, Mr. Bratt, what would have given some other people some notice, this president notice, that he could be in trouble if this happened? Bratt couldn't come up with an example. He said, by the way, Judge, Clinton's tapes did not contain classified information. We have disagreement about that, clearly. Judge Cannon responded. He said, okay, that's okay. Cannon says, well, but Reagan's tapes, they had classified information, right? Didn't they? And nobody prosecuted him. And he said, yeah, that's true. But Reagan was the first president to do that after the Presidential Records Act was passed. And so, he didn't know any better. Then prosecutors continued and they pointed to statements. They said, by the way, Trump's different too, because Trump knew that his retention was illegal. And he made comments about Hillary Clinton, another person who didn't get prosecuted, and prosecution over retaining documents. Defense attorney said, Your Honor, this does not meet the fair notice standard. We can't know that he's going to be prosecuted if everybody else who ever touched touched a classified document or brought them home didn't get prosecuted, why would Trump? So in a motion to dismiss for unconstitutional vagueness, the defense would have to show it's not clear what crime Trump is being prosecuted for. Okay, we got that. The defense and the judge seem to disagree on how far they would need to go on being vague in order to strike down the statute. Trump's defense argued that a vague law was no law at all. You can't have a vague law, and that courts could not rewrite statutes to save them. And Cannon drew a line in that courts could certainly interpret the laws. A break happens, and we come back to discuss the Presidential Records Act, the one that still remains. Defense attorneys for Trump are up. They say, welcome back, Your Honor. Hope you had a nice lunch. They say, Your Honor, presidents since George Washington have taken things out of the White House, and the President Records Act allows for these records to be kept at home. Now, our position, says Trump's team, is that Congress, in passing the Presidential Records Act, gave presidents the discretion to choose, their discretion, what documents to return to the librarians at NARA and what should be kept for public keeps and what else they can take home. Now, the NARA is an archive. They're tasked with record keeping. They don't have any authority to tell a president what records are personal or what records are presidential. This discretion has always been the president's until Trump came here. Now, the defense continued, and they asked, does NARA really have the authority to designate records as personal or not? And if they do, if they can designate, they have that authority. The president doesn't, even though we said that they did in Clinton's case. We have a question. Why they waited so long to indict Trump and claim the case was politically motivated, says Trump. We know why. Because they're motivated politically. Because they had to lob this thing off in the middle of the election season. The defense arguments overlapped with another motion to dismiss, which is, of course, the selective and vindictive prosecution motion, which is saying Jack is misapplying the PRA. They argued, they said, the current administration even agrees with our position. The archive can only request return of the documents, but they have no authority to retrieve these documents. Ask Clinton, ask Reagan. Both NARA and the DOJ, they took the position that they had no say over the president's retention to those documents. And they said NARA has never, ever before made a criminal referral against a former president, and that Trump was never informed of a criminal referral, so he had no notice about this case at all. They said neither the DOJ nor NARA, Your Honor, have the authority to designate personal versus presidential, and we're not asking the court to decide either, because Trump has already done that. They added, if the court could review and designate records, then that would be you making the decision. The president makes the decision. NARA can't make the decision. Sorry, Judge, we love you, Judge Cannon, but you can't make the decision, and Congress can't make the decision either. Look at what NARA has done with past presidents, Judge Cannon. The archive sent a letter to George Bush after he left office. They said, George, do you have any classified information to return? The spokesperson said, no, we don't. Attorneys argued that NARA had operated on an honor system, and then when Trump came around, they indicted him. They said, by taking the documents, Your Honor, that's enough. Trump was designating those as personal records. Thank you for listening to our arguments. David Harbach jumps up for the prosecutors. Jay Bratt's probably tired. Took the position that the Presidential Records Act, he says, Your Honor, that's ridiculous, whatever they said. It doesn't give the president carte blanche to allow former presidents to mishandle classified documents. He says there was no record or evidence of Trump designating the records as personal. He didn't fill out our forms, and he never wrote it down, or he never told anyone, or he never marked the boxes as personal. This feels like a bunch of cope to me. He didn't put a label on it. He didn't use the label maker that we got him for Christmas. To which the judge responded, that was not a fair standard. No one could assume admission of guilt from that. Good Judge Cannon, yeah. He didn't use a piece of duct tape that says personal records on there. All right, now, what's your next point? Thanks. Judge Cannon asks them, I want to know whether the defense reading of the PRA made it so the statute superseded the Espionage Act. So does the PRA take precedent over the Espionage Act, the illegal law? Which one is first? Which makes it the unauthorized possession of the classified information illegal. The judge said, I need some case law. You know, it's difficult to see that it gets to a dismissal here based on the PRA. Government had argued that the defense interpretation that presidents could designate any records as personal effectively guts the PRA, which was intended to preserve presidential records for the public. And the defense, Trump's team, came back and said, that's not what we're arguing at all, losers. And that if the prosecutors are saying that the Espionage Act applies to personal records, then it would have to apply to the diaries as well, so long as it contained classified information. And in the cases of Clinton and Reagan, they argued if Congress really wanted to change that law, they can change it. But that's not how it stands now. And the prosecutors came out and they said, Your Honor, just for the record, I want to assert that we are not puppets of the Biden administration, okay? We're a special arm of the DOJ. Jay Bratt gets super offended, you know, sensitive guy. So we're a special arm of the DOJ. They probably have business cards made up. I swear, I'm not joking. So, all right, Trump leaves, court's in recess. Judge Cannon said at the end of the hearing, she would rule on these two motions motions promptly. We've got a prompt ruling on the one, of course, that was denied. But there was pretty wide consensus on this today. Obviously, this is federal court, so we don't get to hear what happened inside. But Julie Kelly sure did. And she's an amazing journalist and reporter who was covering this all day today. Here's what she said happened there in the courtroom. And she's here with a prediction. She says, from the Florida courthouse, I'm here with a prediction. Dun, dun, dun. Brace yourselves. Says the Robert Hur report in the testimony is the biggest elephant in the room in the hearing. The term arbitrary enforcement was used frequently by both the defense and Judge Cannon. Cannon hammered the fact that no former president or vice president has been charged under the Espionage Act for taking or keeping classified records, including national defense information, which represents 32 counts against Trump in Jack's indictment. Here's Julie's prediction. Cannon won't dismiss the case based on the motions debated today, either vagueness or protection under the Presidential Records Act, but it's very likely she will dismiss the case based on selective prosecution, a motion still pending before her. Whoa! And I've seen that echoed from other people who are on the opposite side of the aisle, said that Cannon seemed very perturbed about the selective prosecution. Obviously, it's ridiculous. Cannon pressed both the defense and special counsel to explain when the, quote, crime begins. She noted the date in Jack's indictment as when Trump violated the Espionage Act was on January 20th, the day he left office. Jay Bratt confirmed the crime began that day, and he was entitled to retain the documents. Cannon again asked for historical precedent as to when a former president faced similar conduct. Bratt said, we don't have one, and said vice president on numerous occasions, right? Because people like Hillary, Joe Biden, Mike Pence, they all skated on criminal charges. Trump was the only one. Cannon said, quote, arbitrary enforcement, according to Julie Kelly, is featuring in this case. Whoa. Also addressed foreseeability. How can Trump foresee that he'll be charged with the crime if you can't define the criminal conduct? Trump could not be aware that he was committing a crime by keeping these materials. She said something like, given the constellation of what happened before, meaning no criminal prosecutions have happened, either of Bill or Ronald or vice presidents or Clinton, Cannon suggested Trump could have reasonably expected he was in the clear. Obviously, because many people were in the clear, and FBI twisted themselves into pretzels to excuse the conduct of Clinton. And so now let's listen to what Donald Trump says about all of these double standards. He was on with Greg Kelly and was being interviewed, asked questions about how he is persevering through all of these prosecutions. And we're going to see what Judge Cannon says about that. Of course, we're going to be covering this one, waiting on a ruling from her. The ruling came out pretty quickly on the void for vagueness. Of course, that was denied. And even if this Presidential Records Act motion to dismiss is denied, there's so much overlap between a lot of these same issues. I think the big one is going to be the motion to dismiss for selective and vindictive prosecution. That was filed under seal, so we have not read that yet. But according to many people, not only Julie Kelly, but many others, there is some serious problems in Judge Cannon's mind about how this case was brought, improperly being applied to Trump, others excused. Of course, that is exactly true and reality. So we're going to be here continuing to cover this, my friends. We'd love it if you subscribed and joined us and invited someone that you know to come over here during our live streams so they can join us as we unpack the truth of what's happening in these cases. We also have some great links down in the description below. RobertGouveia.com is where you can sign up for our nightly newsletter and get access to the PDFs that we just went through. We also have WatcherLodge.com, amazing free events over there. Come and join us for our next Discover Your Purpose and Goals workshop. And of course, WatchingTheWatchers.locals.com, our members-only community where we do live streams in the morning and on Saturdays, and we'd love to see you there. Thanks for joining us, my friends, and we'll see you back here on the next one.